I wouldn't be able to actually work if I didn't have it. I would be sitting there going, you know, who can work like that? I can't even sleep like that. If we're going to allow people to smoke marijuana, are we just not going to allow them to work?
That, in a nutshell, sums up this big marijuana issue that Colorado's top court answered this week. And they said that a worker can be fired for using legal medical marijuana, and with medical pot legal in New Jersey and Connecticut and coming next year in New York State, this is a big issue not just in you know, the Rockies here, but also in our own backyards. Brandon Coates, the guy you just saw, he uses prescribed marijuana to control seizures stemming from a car accident. Without it, he says he literally can't work. But his employer, Dish Network, has a zero-tolerance policy when it comes to drugs. And when Brandon tested positive in a random screening, they fired him, even though he was never accused of being high while on the job as a customer service rep. Court essentially saying that since state and federal laws are split when it comes to marijuana, that they would side with the feds rather than the law of the state of which the man was employed and in which he worked. Now, that's the company's right to have a zero-tolerance policy, and it trumps Brandon's right to use medical marijuana. But the case opens up a hornet's nest of questions. And may I guess I'd start by saying, I guess this clearly says, even though the Department of Justice after Washington State and Colorado decided independently to legalize recreational use, let alone all these other states that this issue would apply to for medicinal marijuana, federal law trumps state law. But does he have a case?
It depends on what you're doing. I think that
does it though, or can it just be summarily, I don't care that you didn't do your job right, I don't care that you didn't show up late to work, I didn't care that you were eating a bag of Fritos instead of answering the call for your customers. If you fail the test, you fail the test, and you're terminated, period.
I think it makes a big difference. I think, number one, you have to be able to perform your job adequately. Number two, what are you doing for your job? So are you driving a truck for Dish Network? And if so, are you going to be driving while under the influence of marijuana? If that's your job, or if you're handling heavy equipment, then by all means, they should have a right to regulate that type of employment. If you're a pilot, you don't want the pilot smoking marijuana, even if it's a legitimate purpose. So you don't have a right to your particular employment. That's a privilege. You are not guaranteed to any particular employment. And you'll find that quite often when you sign up for these jobs, especially if you're not in a union, you're an employee at will, then you consent to a host of things, and which may include them testing you for alcohol or for drugs.
But is it a distinction with a difference, Mark, if it's for medicinal purposes with a prescription, rather than a guy in Colorado, it was legal for him when he went home from work to light up here and to get high, and he wouldn't have been breaking any law. He could have legally purchased it and consumed it. In this particular case, he showed he had a prescription for it, had a medical rationale for it. Is there a distinction with the difference or no?
Well, this is not something novel. Back in 2005, in a case called Gonzalez versus Raich, the Supreme Court upheld this dual regime in California. The case involved somebody who was legally prescribed marijuana in California for an illness and was growing it in his or her backyard and was busted for distribution, even though he wasn't profiting from it. So this dual regime has existed for, 10 years already. What you said at the outset, I think, is very pointed, because we're dealing with academic niceties here, because Holder's Justice Department, and I've had this in cases, come up in federal cases in the last 2 years. There are new guidelines out of DOJ. Yes, it's still considered a Schedule I controlled substance. The FDA says it has no valid medicinal use, which is demonstrably false. But Holder's Justice Department, and it's continued under Lynch, they don't prosecute people unless it's organized distribution, gang, organized crime connection, something like that, not for recreational use. So I think it does make a difference. But what Mayo said is right. Generally, you can be fired for any reason or no reason at all. Maybe Colorado has abrogated, as a matter of state law, the at-will doctrine.
Okay, but here's my question. What's the difference if a guy, right now, every state of this country, forget about, pot here, you can get a drink after work,
That's right.
okay? You can't be bombed at work, you can't drive drunk, we all know that. But if you go home and you make yourself a cocktail or 2 or 3, you're perfectly legal within your guidelines. If Dish decided that they were going to test if people had trace alcohol in their system in contrast to marijuana, you know, to me, this is legal. What he did was legal in consuming marijuana, and he had a medical reason to do so. So that is different that's with a distinction than recreational purposes in Colorado. So for me, are you going to say they could have fired this guy if he had drinks at home, even though it didn't impair his ability to work?
No. And
so what's the difference then if they can't do that?
The difference, and again, it is unfortunate. The difference is it's not legal federally. That's the difference.
Even medicinal.
Even the federal law still holds the possession of marijuana to be illegal. The bigger point here that you talked about earlier is that you're going to start seeing more and more and more of these issues arise, and it's an inconsistency that is just intolerable. You've got states that have legalized medicinal marijuana for all the right reasons, but you have the feds who aren't prosecuting the laws, and yet those laws are being upheld. And it is completely unfair. So what needs to happen is the Congress needs to
reschedule.
That's right, absolutely.
But
Congress
here's the
will
point,
reschedule
though.
and you'll be okay.
The employer could say, have a zero tolerance policy toward alcohol too. I don't want you having any trace, as long as it's spelled out in a written policy, again, assuming they're not at-will employees. They could make a policy and say, if I find, we're going to test you and screen you randomly, any alcohol trace in your blood system, you're out of here. There's no recourse.
There's an element of Hobby Lobby here where you can
because
sit
when I
there.
looked it up on the internet, the Hobby Lobby ad came right in my face.
Yeah,
So there
exactly.
is.
Mark, isn't it
obviously.
illegal in this state to fire somebody for doing something legal when they're not on the job? Isn't that the whole issue? And he's trying to bring this within it?
Because this was brought under a statute, and the wording of the marijuana statute says you have a lawful right to use marijuana. The Supreme Court of Colorado, or the High Court, construed it, said no, you don't have a lawful right because it's illegal
Under federal law.
But theoretically, why couldn't you if they're at will?
And I want you at home to weigh in on this one too here. This is our question tonight, so obviously go over to Facebook and Twitter and answer it. Should testing positive for smoking pot get you fired, even if it's in a state where it's legal? All right, coming up next. This is not some hypothetical bad sci-fi movie. This is happening for real. And trust me, it'll happen at your mall too. While you're shopping, the store could be spying on you. Retailers now have facial recognition technology that can tell them tons of information about you, the shopper, as soon as you step in the store. Should you automatically lose your privacy? Because basically, the court decided, or at least the panel decided, the answer is yes.